Hey everyone, welcome. I'm David Drumhiller with Whitehill Financial.
And I'm Lisa Whiteman. Thank you so much for being here with us.
This webinar was originally recorded in February of 2026, and it covers the most common misconceptions we see. People think estate planning is only for the ultra wealthy, but it's not.
We were joined by estate planning attorney Sean Walsh with Owada Law in Lacey, Washington, to break down this very important topic, estate planning, and what it actually means, especially if you have kids, a blended family, business, or just want to make sure that things are easier for the ones you leave behind.
We cover wills, trusts, powers of attorneys, healthcare directives, and what probate really looks like in the state of Washington.
So stick with us as Sean covers this very important topic and especially hang around for the Q&A at the end for some valuable information.
Let's jump in.
Well, thank you everybody for joining us here today. For those of you who don't know us, Lisa and I are part of Whitehill Financial. I'm David Drumhiller. We formed this when we left WSECU together, and I'm based here out of Pullman, Washington. Yeah, happy to have you guys here, and hopefully you guys have a great time, and I'll let Lisa introduce the rest.
Thanks, Dave. So for those of you who don't know me, I am Lisa Whiteman of Whitehill Financial. I am in our Lacey office, and I've had the pleasure of being next door office mates with Sean for the last year and a half or so. This is Sean. He's from Owada Law. Sean is a Pacific Northwest native born in Seattle and a longtime resident of Olympia. After earning his degree from Evergreen State College, he spent 10 years working in information technology before following his passion for the law at Lewis and Clark Law School in Portland. Today, Sean brings nearly 2 decades of legal experience to his practice, where he supports individuals and business owners with estate planning, probate, business law, administrative matters, and family law. He is known for his approachable style and commitment to helping clients feel informed and prepared for the future. When he's not working with clients, Sean enjoys traveling, camping, and playing board games with his friends and family. Thank you for joining us, Sean, and why don't you take it away?
Thank you, Lisa. Thank you, David. I am happy to get this thing started. I do want to preface that I'm using a slightly new technology here, so please bear with me a little bit because I don't know exactly how everything's going to work. And if you can't hear me, raise your hand and let me know. If you can't see something, certainly let me know that as well. And there will be opportunity for questions at the end. So if it's that kind of a question, feel free to hold on to it and let me know at the end. But again, welcome to the estate planning and probate seminar on this sunny February 12th. Let's see if this works. Oh, look at that. Just like that. What is estate planning? So that is a frequent question I get. What exactly is it? I think everybody has their own ideas about what it is. And is, in essence, from my point of view, it's the method of preparing for the transfer of your property to your heirs, your beneficiaries. It can also include planning for your end of life plans and your medical wishes, your personal wishes about what you want to have happen, and also planning for the consequences if you are temporarily or permanently disabled or unable to voice your own opinion, to kind of pre-establish what your desires are so that those things actually will happen. And it covers a wide variety of people in a wide variety of circumstances, and it can be, very varied based on what exactly is your circumstances. As far as who should have an estate plan, everyone should, is the easy answer. And to some degree, everyone does have a plan. If you don't know what your plan is, there's still something that's going to happen. But really, the people that should have an estate plan are the people who want to actually take control of that, be assertive or proactive rather. And they want to control where their assets go when they pass. They want to ensure that their blended families are provided for, because we have families of a variety of ways that we become families, and loved ones that we have long-term and important relationships with, but the law doesn't necessarily always recognize those. So those are circumstances where estate planning is definitely necessary. If you have a history in your family or you're concerned about the possibility of an illness such as dementia or an injury that would make it difficult or impossible for you to handle your own financial or medical affairs, you certainly want to make plans in advance. Business owners particularly have to make planning, and your estate planning should be part of your succession planning for your business. And then special circumstances, if you have a loved one who is unable to manage their affairs, and you want to make sure that they're provided for when you are unable to take that role, when you have minors, children, not people who dig into the earth. And if there's other issues in your family that need special attention, certainly those are things that you'll want to address. Specifically with business owners, you spent a large portion of your life and efforts to try to build your business into what it is. And you want to make sure that effort and your legacy continues into the future. That's something that needs to be included in any estate planning that you make. Also, as a business owner, you probably already know that there are special tax and asset considerations, which require special planning. Business assets are not the same as the more typical assets that a non-business owner might have. And the tax implications can be complicated and often unnecessary if you pre-plan in advance. So well-structured estate plan can ensure a smoothness of that transition for your business into retirement, into your end of life. From my point of view, those are all part of estate planning. It includes both of those things. So there are several documents that are included in the basics of an estate plan. The primary document is a will or will and testament that is almost always going to be a recommended document. That is a fundamental document that instructs the court and a person who in Washington law is called the personal representative, but in other laws is called the executor or executrix, the person who is to handle your estate's affairs. And in the will instructs them what they must do. And it is the document of last resort. So if there is something that doesn't have any other methods of transfer or any other ways in which it's going to be dealt with, the will is the document that's going to be referred to figure out what to do with this circumstance, this asset, so it's always going to be an important thing. And then also often people have a trust. So a trust is a very powerful tool. And like most tools, it is only useful when you need it. So when I meet with clients and talk to them about what their goals are, what their concerns are, when I see a need for a trust, that's when I advise them to have one. There's a lot of stuff you see on the internet and in the news and stuff about how a trust is important, and they are very important, but it's very important also to know that if you have a trust, it's going to increase the cost of management of your assets, both in your life, perhaps, and also certainly in your estate planning. And so you only want to have a trust when you actually have a specific purpose for it. A power of attorney is a document where you give authority to another person to make decisions on your behalf because you are unable to do that. There are typically a financial power of attorney and a medical power of attorney. The financial power of attorney is directed towards instructing your financial planners, your banks, and or that they should that a particular person has authority to make your decisions, to pay your bills, to manage your affairs. Medical power of attorney is directed to your doctors and your medical care providers with the same thing. It identifies the person who can make decisions for you. A power of attorney should probably not get too much in. There's another slide in here later on with more about each of these. An advanced healthcare directive or a living will, those are two names for the same thing. These are instructions about your end of life care. They are documents that you create in which you put specific instructions to your doctors, to your loved ones about what you want to see happen, and they are legally enforceable. and they can be very useful in some circumstances because they take those difficult decisions out of the hands of your loved ones who are already maybe struggling with the circumstances that they find themselves in, and give them the confidence to let you have the kind of end of life care that you want without being concerned that they're making some decisions or mistakes or something that you might not have wanted for yourself. A community property agreement is a agreement in Washington State is a community property state. And that means that if you are married, then you are presumptively creating community property, and community property agreements tell the world, really. I mean, they're legally binding documents that define which of your property is community, which of your property is separate, and what should happen to those properties under certain circumstances. A community property agreement is vital if there's any ambiguity about whether some of your property is separate or it's community, because the law treats those things differently. And if you want certainty with regard to how your assets are going to be treated, then a community property agreement is an important part of that. Beneficiary designation forms. There are many accounts and assets that have sort of automatic transfer processes, and that's a beneficiary designation form. So estate account, financial accounts, bank accounts, many things have beneficiary designations, retirement accounts. It's important to consider these when you're making an estate plan because they can defeat your estate planning if you have some instruction in your will that says to do one thing and some instruction in your beneficiary designation forms that says another thing. The beneficiary designation form will be followed before anyone reads the will. Now, there are ways in which in a probate case, the will can supersede those beneficiary designations, or the probate case can, but certainly it isn't cost effective to have something happen and then go to court to try to undo that. So it's important to make sure that those things are in line with your intents. Insurance policies are another document of your estate plan. It's just another tool to ensure that your loved ones are cared for. And in some cases, investment tools. Those are not really, it's not really a legal advice issue, but more of a financial planning advice issue with regard to how to use those as investment tools. But there are many options in which insurance policies are useful. And then everything else that is related to your estate plan, instructions for your funeral, disposition of your remains, property deeds. I remember there's a story that Muhammad Ali had a book that he carried around with him, which was his funeral arrangements that he wanted. And it was several pages long. And he would, whenever he met somebody new, that was the thing, the go-to icebreaker that he would break out was this book of his funeral arrangements. And, I mean, if it's important to you, and it's something that you want to be a part, that you want to ensure is going to be happening, then you want to make sure that it's in your estate plan. The will, see, I told you there were other slides here. So why is the will the most important document? Well, because it is the primary document that is the default document. It's the primary document in that it's the first document that goes into a probate case, and it's the default document in that if there isn't any other document that applies, it's the document that applies. It's legally binding. It ensures your wishes are going to be followed with regard to your assets because it's legally binding. It tells who you want to manage your affairs, and that can be with as much detail as you or ambiguity as you like. I mean, I've seen it where people wanted their will to name all three of their children as co-personal representatives and were unable to do anything but unanimously and together, but they could do anything they wanted the estate. So, and we talked about that and the pros and cons of that, and how, if your children are not going to get along, that could be a disaster. But if they do get along, then, that might be the easiest way for them to deal with some of the complicated assets that this particular person had. And so I recommended with that person that we sit down with the children and we talked to them exactly what the plan was and what we were going to do and how we were going to leave it open for them to be able to do what they felt was the best at the time. And that seems to have worked. I mean, in that particular case, I've certainly also seen it where the families were not the kinds of families that could get along in that way, especially at that time when emotions are raw and people are really grieving. The will can also nominate whom you would have as a guardian for your children. The default under the law is your spouse, but in the absence of a spouse or in other circumstances, that nomination is going to be followed. Intestacy means a person without a will. That's the will and testament, testacy. Intestacy is Latin, no will. If there is no will, the law provides a means and instructions for how to dispose of your estate. And it's, in essence, it says that all of your community property will go to your spouse, and your separate property will go partly to your spouse and partly to your children, depending on whether you have children or not, or entirely to your spouse. If you do not have a spouse or children, all of your assets will go to your parents. And if you do not have parents, then to your brothers and sisters and their children. And if you don't have brothers and sisters, to your grandparents. If you don't have grandparents, to your cousins who are descended from your aunts and uncles and their children and so on. And if there are none of those to be found, then all of your assets will go to the state of Washington. So if that's an outcome that you want to avoid, that is a reason to have a will. As I said, the will is the default document. It applies to your entire estate, regardless of where or how it is situated. The will is also an important document for tax planning purposes. There are two primary taxes that will apply or may apply, I guess I should say. So there's an estate tax in Washington state if your estate is greater than $3 million, and it's actually more than that now and probably will be more than that next year, et cetera. And there's a federal estate and gift tax that applies to estates that are greater than $13 million. There are ways to mitigate the implications of tax on your estate using trusts, using different types of gifting vehicles. And so the will is a very important part of that. It can also preserve tax benefits. So one of the things that can happen is that an estate that passed from one spouse to the other spouse, that first spouse has an exemption from estate taxes that could get lost if they didn't do tax planning in their will. And then their other tax planning is when assets pass via a will, the assets get a stepped up basis, which can help with capital gains taxes. Recently, I had helped a person who had attempted to transfer their house to their children while they were alive. And the concern was that they had purchased that house in 1953, I think it was. And as you might imagine, the value of that house had increased considerably between 1953 and today. And so when they transferred it in life, their children did not receive that stepped up basis. And so they had a $500,000 house that had a basis of $30,000 for capital gains purposes. And so we were able to fix that and get back to where they could get it through an inherited process and get advantage of that stepped up basis. Disadvantages of a will: it does not avoid probate. And many people feel that probate is something to be avoided. I personally, and maybe I'm biased about it, but I don't know that I agree necessarily. I think there are certainly some states where I hear horror stories that probate is very terrible. But Washington state probate is actually relatively simple and relatively low cost. The other thing is that sometimes there's just no possibility of avoiding a probate. Probate is the default process for estate transfer. Another disadvantage of a will is that it becomes a public document once it's filed. So if you are concerned about privacy, there are other ways to transfer your property that you will want to take advantage of, because the will be filed in a public court record. And while most people don't go through the wills and try to find what people did or whatever, certainly they could if they wanted to. And here I go into detail with something that I already talked about. So intestacy, what happens if you die without a will? The intestate succession laws are applied. Now, I do want to add that I practice law in Washington state. Every state has their own probate laws. So this information really only applies to Washington state. Now, it does apply to property that is not in Washington state, because you can own community property in Washington state and that community property is somewhere else, or separate property for that matter. But if you were probating an estate in a different state, a different set of rules might apply. For example, Oregon is not a community property state, so they don't have the same intestate rules. So if you are married with children, 100% of any community property goes to your surviving spouse, and 50% of your separate property goes to your spouse, while the other 50% goes to your children. If you are without children, 100% goes to your surviving spouse, 75% goes to all of your separate property also goes to your surviving spouse, and 25% to any of your surviving parents. And then if you are unmarried and there are no children, if you're unmarried, it goes to your children. If you're unmarried and there are no children, it goes to your grandchildren, or to your grandparents and their other children, your aunts and uncles. One thing that never gets covered in intestacy succession is those blended families. So, for example, I have a child from a previous relationship, and my wife has a child from a previous relationship. If I were to pass away without a will, all of our assets, because we only have community property, all of our assets would go to my spouse. And then all of our assets would go to her child. If she were to pass away, all of our assets would go to me. And then all of our assets would go to my child. Her child would get nothing under that circumstance, and my child under the first circumstance would get nothing under the law. So under those sorts of circumstances, it's absolutely vital to make sure that you have a will to ensure that those sorts of unequal and almost certainly undesirable results don't. And for families that are more complicated than ours, certainly you need to have a will to take those things into consideration. A trust. So that the trust law is very old law, comes from England before the United States ever existed. And it is, in essence, a method of transferring property to avoid probate. If you think of ownership of property as being a number of rights. So you have the right to sell the property, you have the right to develop the property, you have the right to destroy the property, you have the right to use the property. Those are all different rights that you could have. The trust is a method of taking some of those rights, the legal ownership of the property, and giving it to a trustee, while taking other of the rights, the beneficial interests in the property, the use of the property, if it's a house, you could live in it, that kind of thing, to the beneficiary of the trust. And you split the ownership into these two roles, a trustee and beneficiaries. And that way, the trustee is a fictitious legal entity that owns the property, and it never dies. No probate is necessary. The asset is in trust for perpetuity, basically. In reality, it isn't, but that's a more complicated situation. But the idea is you split this, and then if a beneficiary passes away, there's a list of beneficiaries who get it next, and the trustee then just transfers that beneficial interest in the property to the next beneficiary. Other things you can use a trust for are to limit the access to the property. So, for example, if you are giving money, or basically money, to a minor, and you want to make sure that they have it for some future need or want, like school or the ability to buy a house at some point and not spend it all on travel on their gap year that turns into 3 gap years, you will want to put it into a trust. That will limit that minor's ability to use the asset for whatever they want. You can put it into a spendthrift trust. That's a type of trust where the asset can only be used for the necessities like housing, food, whatever the necessities are that are defined in the spendthrift trust. And that keeps a beneficiary from wasting the property. You can also put an asset into trust to protect a person's rights to benefits. So if a person has a medical disability and they have benefits that are tied to their financial resources, trust can be a useful tool to make sure that they maintain that eligibility. The trustee has the legal title. The other party, the beneficiaries, have beneficial title. The trustee has a fiduciary duty to the beneficiary. A fiduciary duty means that they have a duty of care, a duty of trust, and a duty of fair dealing. I'm saying it wrong. They have to act in good faith on behalf of the beneficiary. That is to protect the beneficiary from trustees that, might otherwise do things they're not supposed to do. Beneficiary always has a right to ask for an accounting from the trustee and has certain other rights, like they can appeal to the court if they think a trustee is misusing their power, that kind of things. Trusts are of 2 fundamental types, revocable and irrevocable. A revocable trust means that you can get rid of it. So you can put the asset into the trust and then you can change your mind and take it back out again. An irrevocable trust means once you put it in there, it's there forever. There's no going back from that. If you are using a trust for a tax benefit purpose, the irrevocable trust is, I'm going to say, always required. There might be some limited set of circumstances I don't know about where you could get away with a revocable trust. Generally speaking, tax entities are going to require an irrevocable trust to get any tax benefit from your trust. Revocable trusts are more flexible, obviously, because you can change them more readily while you're alive. If you make a trust while you're alive, like a family trust or something like that, you can make yourself the beneficiary. If it's revocable, you can change it from time to time. While you're living, it becomes irrevocable the minute that you pass away, and so your heirs can't change the parameters of that trust afterwards. But trusts have a tool for many purposes. One of the primary purposes is to avoid probate. Irrevocable and revocable trusts defined, they both avoid probate. Revocable trust offers more flexibility. I don't think I missed anything from there. What do I need these slides for? Oh, I did miss also asset protections from creditors. Typically, an irrevocable trust can give you some your asset protections from your creditors. You can do that to some degree also with a revocable trust, as long as you are not the beneficiary of the trust. So there's like third-party funded trusts so the beneficiary is not you. You still have some control over the trust, but you can protect the beneficiaries' creditors from getting to the asset that's there really for their housing or something else that you want to make sure that they have the ability to do. Another two other types of trust to think about. One is called a testamentary trust, and one's a living or intro vivus or inter vivos. My Latin is terrible. I apologize. Trust is created in your will. So you basically put in the will instructions to create a trust. The personal representative will then transfer the asset from the estate into that trust. And then that the trustee does whatever they are instructed to do with that asset for the benefit of the beneficiaries, according to the trust document or the trust instructions that are in the will. That a trust is a separate legal entity, a fictitious legal entity. So it has a tax ID. It couldn't generate income. It will have to pay taxes on income that it generates. And so these are part of what I was talking about how when you make a trust, there's additional costs associated with it. However, if a trust isn't funded, doesn't ever generate any income, That means it doesn't have any assets. So there's no income nothing to make income with. And so that's one thing to do. When you create a trust without funding it, you're just sort of creating a vehicle to do something later with. And that's similar to a testamentary trust. So you've written it into the will. It's technically not created yet either, but it doesn't get funded until you pass away. You can amend it during your life. And if it's written into the will, you can amend it with the way that you would amend a will, but you can also have a will that just refers to a trust, and you can amend that more freely than you could a will. As I said before, it becomes irrevocable upon your death. There's no record keeping requirements or tax returns or title transfers because there's no funding. So it's a tool that you use to augment basically your estate planning at end of life decisions. A living trust is created separately from your will. It can be funded while you're alive. You can transfer property into it while you're alive. But once it is funded, you do need to keep those records. You may need to pay taxes. The title transfers can incur costs. There's some management that needs to be done. Different types of trusts that there are. These are different ways that trust can be a tool for your planning. Spendthrift trusts I already talked about. A charitable trust can provide you tax benefits while you're living. One thing that sometimes people will do is create a charitable remainder trust. You put an asset into the charitable remainder trust. During your life, you get the benefit of the asset. And upon your passing, it is transferred to the charity that is designated in the trust. And there can be tax benefits. The income during your life can have less tax implications. Special needs trusts are useful for loved ones who need particular assets for particular purposes, or they want to make sure that their eligibility for government assistance is not impacted with an inheritance. A disclaimer trust is a type of trust that allows the spouse to disclaim a part, refuse a part of their inheritance to preserve a tax benefit to the deceased spouse. So this goes back to that if the spouse passes away and it's all community property and it just transfers automatically to the surviving spouse, then you don't preserve any tax exemptions that the passing spouse had. With a disclaimer trust, you can do that. A qualified terminal interest property trust is another way to do it, preserving tax exemptions. The big difference between the disclaimer trust and the Q-tip trust, they're kind of the same thing, but the big difference is that one is the disclaimer trust is more optional. The Q-tip trust, you just designate specifically what happens. And then personal representative who's managing your estate follows those instructions. Estate tax. I did talk about this before, but I guess I forgot how much the federal filing exemption is now. So almost 14 million. The Washington estate tax applies to estates that are worth more than $3 million. And it applies on the first dollar over the $3 million threshold. So if you have a $3 million and $1, you pay 10% tax on that $1. If some of your assets are outside of the state of Washington, that can be prorated by those other assets. And it includes assets that are not passing through probate. And there are rules about filing your Washington state tax return that you should follow to avoid penalties. The federal estate and gift tax, it is in your life gifts apply to this threshold. If those gifts are above the annual threshold, which I believe is about $30,000. So if you give somebody $1 million while you're alive, that means that your estate tax exemption is, for the federal purposes, is 1 million less. So it would be 12.9 million. That is not the same as Washington's estate tax. Washington's estate tax can be avoided by giving away your property before you pass away. However, there are other possible complications and tax consequences of doing that, like capital gains tax that we talked about before. Income tax has to be paid for an estate. An estate is a legal entity. And so if it generates income, there's a possibility of having to pay income taxes. Ideally, you have a well-created estate planning. Your estate is relatively short. I think later on, I'll talk about the probate process, and you don't really have to concern yourself with the estate taxes because the income has also been transferred. But if the estate takes a long time to manage, this could be a problem, depending on the nature of your estate. And this is one of the reasons that frequently when I open a probate and I instruct the personal representative to open a bank account for the estate, that they open a bank account that has no interest, doesn't generate any income. We don't want it to generate income because income means record keeping and record keeping means money. Nowadays, maybe that's not so hard because it doesn't seem like any bank accounts have interest anymore. Capital gains tax is a tax that's owed on the profit after the sale of an asset. So, for example, that I gave earlier, the person that purchased their house in 1950 or $30,000 when they sold their house. Maybe house is not the right example because there's an exemption for your residence, but let's just ignore that for the moment. So when you sell your house for $500,000, you have to pay a tax on the difference between what you bought it at and what you sold it for. A stepped-up basis applies to almost all assets that are transferred in the process of your estate planning at your death, either through a will or a funded trust at that time, means that the inheritor, the person who receives the asset, gets it at the basis that the value it was at the time they received it. So all of the capital gains that were incurred during your life don't apply to your heirs. Often a very important thing to take into consideration. Community property agreements. So in essence, as a couple, a married couple in the state of Washington, you can enter into an agreement with your spouse to define your property however you want. You can define your property as all community property. You can define your house as your separate property and all your cars as your spouse's separate property. You can do whatever you want. It is in essence the same as a prenuptial agreement. So you can make rules about what happens with your property based on certain circumstances. I like to call them postnuptial agreements because I think that's hilarious. But you have a lot of freedom of what you can do with a community property agreement. One thing you can do is define all your property as community property, which means that once the first spouse passes away, all of it goes directly to the other spouse, automatically transfers, no probate necessary. You don't have to file anything really. It's very simple. The disadvantages are that it can create unintended results with blended families. It doesn't give you any sort of fine-tuning control over what happens with these assets. It only works for couples who are residing in Washington at the time of their death. So if you move to another state that doesn't have community property rules, you will need to reconsider your estate planning. And you're locked in ways that you wouldn't be if you had a more sophisticated estate planning tool. But definitely an important tool. It is important to address, like if you are on a second marriage and there's assets that you both brought into the marriage and you want to make sure that you have a set of rules about what to do with those assets, or if you or your spouse have acquired a significant asset by gift or inheritance, just to set the rules and enforce legally enforceable rules as to what will happen with those assets. The powers of attorney, the primary words to think about are the principal and the agent. The principal is the person who is making the power of attorney. Agent is the person they've given authority to. And there's a whole lot of case law about agency and principals. The agent is acting on behalf of the principal. So the agent is, when acting in good faith, is not liable for their own actions in the same way as they would if they were free to just doing whatever they're doing. The principal and the agent have duties to each other. The agent has to act in good faith on behalf of the principal and follow the authority within the document. The document is legally enforceable. It's primarily a document to get somebody else to do what you want them to do. So when your agent shows up at the bank and says, I want to transfer this money from here to there in order to pay the mortgage or this bill or whatever, the bank teller will say, well, what authority do you have to use this bank account in this way? And that's what the power of attorney does. Similarly, with the medical power of attorney, if somebody's making medical decisions on behalf of somebody else, the nurse will listen to them if there is a medical power of attorney, whereas they won't if there isn't, or they may not. It's about forcing people to do what you want them to do. Two big differences between different types of powers of attorney is that a power of attorney by default expires if you become incapacitated or you pass away. If you want your power of attorney to survive your incapacity, you make it durable. The durable power of attorney, the idea in the law is that if you're not able to revoke your power of attorney, which you ordinarily have a free right to do, we're going to just assume that it's safer to revoke it for you if you're no longer able to do that. So that's the default. You make it durable, and then it lasts beyond your ability to revoke it, which is somewhat dangerous. So you want to make sure that you're giving this authority to people that you trust. Springing power of attorney is a power of attorney that comes into effect only when something happens. So ordinarily, when you sign the power of attorney, it comes into effect immediately, but you can write into it that I only want it to come into effect on when I turn 75, or when this other thing happens, or more frequently, when I become incapacitated. So you get a durable springing power of attorney that only becomes effective when you become incapacitated. So the person who is named in it gets a document from your doctor that says you're not able to make your own decisions. They keep that document with the power of attorney, and that proves that this power of attorney sprang into effect at that point in time, and it's durable past that. So that durable springing power of attorney is about planning for the future when you might not be able to make your own decisions. You can put as many limitations or instructions as you like in your power of attorney, or you can leave it pretty wide open. One of the things that frequently requires specific instructions is gift, like whether you want the person who is your agent to be able to continue to give gifts on your behalf or to themselves. For example, if you have a tradition of giving gifts to your children and you name your child as a power of attorney in a durable springing power of attorney, can they give them a Christmas gift to themselves on your behalf? Now, if it's a relatively small gift, probably doesn't matter, but I think everyone can see how that could frequently create a problem. So that's something that often the power of attorney has to deal with. Healthcare directive is the specific instructions for your end of life care. So if you are been diagnosed with a terminal condition for which certain healthcare options might exist, but they will only serve to prolong your life, this is the instructions at that time, like whether or not you want a feeding tube or artificial hydration or experimental treatments that may or may not have very high chance of success, that kind of thing. What this does primarily, in my opinion, is make the instructions that take that burden away from your children who will otherwise be forced to make these choices. So it is a sensitive and important document, and certainly something to be part of your estate planning, though. Disposition of your remains. This is a little bit complicated. A lot of times people will put this into a will. The problem is that the will is not necessarily looked at until after these decisions have already been made. But there are all sorts of things that you can do with this about what you want your funeral or memorial plans to be like, including if you want the more modern options that are now available, like the natural organic reduction or decomposition instead of embalming or cremation. Or, if you want to wait, or, some more traditional things. These are instructions that you probably, and plans that you should probably put in place to make sure that they happen. I think I'm going slow, so I'm going to try to speed up a little bit. But probate is the law process of administrating your estate. Like I said before, I think in Washington, the costs are relatively low and it's relatively simple. There's a law that allows for arbitration processes and takes a lot of the numerous things about going to court out of the process if that's written into the will. So if you don't want the court to have oversight over everything that the person does, you can write that into your will. But if court oversight is required, that can definitely increase the costs and the timing for administering an estate. The first step is to file a petition to put the will into probate and identify who's going to be the personal representative, and give notice to all of your potential beneficiaries and heirs, and give everyone an opportunity to say whether this is the real will or, have some sort of will contest. And then that personal representative, assuming that they are appointed without much hassle, they have 3 main duties to do. They have to collect and administer your assets. That can mean a variety of things depending on the nature of your assets. They have to identify and pay all your valid debts. And then they have to distribute any remaining assets according to the will's instructions or the intestacy laws. The court oversight and also a bond can be required. Those are tools to help ensure that your estate is not mismanaged and to protect from misconduct. If you are concerned that the personal representative that you've identified might not behave appropriately, then those are tools that will protect your other beneficiaries from their misdeeds. Bond is just a type of insurance. So if they, take all the money and go to Owada, then there's an interest, there's an insurance that pays to help make the other beneficiaries whole. In Washington State, one of the other things that makes probate easier is they have alternate methods of management, like the small estate affidavit. If the whole estate is worth less than $100,000 and all the debts have been paid and there's no real estate, then you can just file a small estate affidavit and manage the estate with just one filing. Very simple. It does require all of the other siblings to sign off on it. It is pretty easy. And I guess I thought there was going to be more than that, but I'm rounding out to the very end here. So thank you for that. I did see a bunch of things pop up, so I'm hopeful that those are questions.
Yeah. Why don't I just kind of tackle them one by one? And thank you, Sean, very much. That was really great information. So we've just got a couple questions. I know we're running short on time, but we should be able to get through these. The first question that we had asked is, Don would like to know more about avoiding the public aspect of a will filing, and if there are certain types of will to request if you don't want it to be public record.
Yeah, so the short answer with making a will not a public record, I think you could theoretically file a motion with the court to seal a will if there was some sensitive information in there. My guess is that might be an uphill battle because the default is that court filings are public records and the public has a right to know what's going on in our courts. The more simpler way to keep your estate planning, keep your private matters private, is to create a trust that's funded through your will. And then the trust document is a private document. The will is filed, but all the will says is give everything to this trust. And so while it says, so you'll have the probate, and the probate will say there was an estate, that the estate was solvent, the estate was greater than, you could just say it's solvent, which means, you had more assets than debts. And then the only thing that will be in the public record is, was everything transferred to this trust as the will said? Yes, good, we're done. And so That's one way. And another way would be to create an in-life trust and just sort of avoid probate altogether by putting your assets into that while you're alive. So, but because the trust is not necessarily a public document. However, if there is a dispute about the trust, so if your beneficiaries get mad at each other and they decide to fight each other about stuff, that the trust document could very well become a public document.
Great. Thank you so much. I think that pretty much well answers the next question, but I'll ask it anyway, just in case you have any additional highlights you want to hit. But Don also had a question about whether you have to have a will in order to execute a trust.
No, you do not.
Okay. And then John asked a great question. In a trust with co-trustees and one of the co-trustees dies and a successor trustee is appointed in that trust, do you have to get another trust identification? I'm assuming it says trust ID number. I'm assuming that means tax identification number.
No, the trust will have the same tax ID number that it got when it was first created. The successor trustees don't change that.
Okay, great. And then Don has another great question. Which of these documents discussed need to be notarized? I'm assuming the answer to that is all of them. But
Well, yeah, no, it is not all of them. But so under the new rules, powers of attorney have to be notarized. However, there is a provision in there to get it witnessed by two uninterested witnesses. So you can avoid the notary requirement that way if you follow those rules. I don't do that because I have a notary, and notary is easy for me. And it's also the problem with using witnesses in lieu of the notary is that if somebody were to challenge the document, you would have to go find those witnesses and get them to testify. The community property agreement does not need a notary, although it might be a good idea. I don't know why you would have a notary on a community property agreement. The notary would just identify that the people who signed it were the people who signed it. But if it's you and your spouse, then it would be hard not to identify those people. The will does not need a notary, and a trust does not need a notary. However, if you want your will to be self-proving, which is a one way to shortcut in the probate process, then you do need a notary and an affidavit signed by the two witnesses. So,
got it. Great. Looks like we got two more. Randy looks like she asked, are special needs trusts different between states? Can someone from California move to Washington with a special needs trust, or would it have to be updated for the new state?
That is a relatively complicated question.
Okay.
The short answer is you would not need to do that. So you create the trust in California or Washington, and it exists there, and you in the trust define the law that applies to it, or it applies, or if somebody were to dispute it, there would be a process in the court to determine what state's laws apply to it, most likely the state where the trust was made. But you could also identify specifically that you want another state's trust law to apply to your trust. But then when you move to another state, that trust keeps its legal status as a California spendthrift trust. And so it's subject to California law. Even if you were to do something with it in the courts in Washington state, the Washington state court would then have to look at Washington law, interpret the law, and apply it to the trust, which could be complicated. And if you're working with entities that are wholly Washington state entities, there may be a desire to update that trust for those reasons. But the trust itself wouldn't necessarily need to be updated.
Okay, great. Just two more quick ones. I think they should be pretty quick as we're over on our time a little bit here. Sherry asked two questions, and maybe you can answer it in one fell swoop. When is it okay to use online will type arrangements? And then her second question is, how is probate filed?
Okay. So the online will thing. So there's my two big concerns with online resources which are prevalent, and certainly a lot of them you could use, and you could get a document that does what you want it to do and is legally binding. The two big concerns are that because you don't have the advice of a lawyer from the state that you're at, you won't know that you have a legally binding document or that it's a document that does what you want it to do until it's being challenged. And that could be too late to fix it. One of the things I like to tell people about getting an attorney to help them with these things is not only do you get somebody that's got the knowledge of the law from the state to apply to your circumstances, but you have somebody to sue if they messed up. So if you go online and get your own will and you fill it all out, and then it does something else when the time comes, you have no one to blame but yourself. And if that's a disaster, that's a disaster. So I don't like to, recommend that people not do self-help, because I certainly think that for lots of things, self-help is a great way to do things. But my two main concerns are that the online resources are not going to be state specific, and you don't have a guarantee that you've got a document that does what you want it to do.
Then her follow-up question was, how is probate filed?
How to file probate. Yeah. So you file probate in Superior Court in the county where the person passed away, where the person had real estate, or the county where the person who's going to be the personal representative resides. And you file a petition, you pay a filing fee, which I think is $260. And you set a hearing to admit the will into probate, to appoint the person as a personal representative. And then you have 30 days to get notice out to all of the heirs and all the beneficiaries and all the assignees who are identified in the will, designees. Then they have an opportunity to challenge things. You do go through the process of administration of the estate, including optionally publication notice of the passing, identifying and finding creditors, making sure that their creditor claims are valid, identifying and collecting assets. And then at the end, there can be a final hearing, or there can be a process that is more of a shortcut process where you file a notice of intent to close the estate. And as long as no one objects, then the estate automatically closes. So that's probate in a nutshell.
Thank you for that. Well, I don't know about everybody else, but I found this really insightful, and we really appreciate having you on. Thanks for joining us tonight, Sean. And thank you, everybody, for joining us. As always, if you do have any more additional questions, we will post this video on our YouTube channel and on our website, and we'll attach Sean's information so that anybody wishing to get a hold of him can do so. Thank you very much, everybody, and have a great evening.
Thank you.
Thank you.